federal appeals court has delivered a significant victory to the Trump administration, siding with the Environmental Protection Agency, EPA, in its bid to freeze billions of dollars and terminate contracts with nonprofits managing a green bank designed to fund eco-friendly initiatives. This bold move has sparked controversy and raised critical questions about the allocation of public funds and the role of government in environmental stewardship. In a 2-to-1 ruling, the divided federal appeals court backed the EPA's stance, asserting that the agency should not have been restrained from ending the grants. The court deemed that the arguments put forth by the climate-focused organizations do not fall within the purview of federal district court, but rather should be addressed in a federal claims court, which specializes in contract disputes. This decision marks a substantial setback for the nonprofit groups, who argued that they could only seek financial redress in district court. With roughly $16 billion in funds at stake, the groups sought an immediate release of their funds, claiming that the freeze had effectively halted their operations and threatened their very existence. U.S. Appeals Court Judge Naomi Rao, appointed by President Donald Trump, penned the decision, emphasizing that district courts lack jurisdiction over claims alleging arbitrary termination of grant agreements. According to Rao, such disputes are fundamentally contractual in nature. Joined by Judge Gregory Katsas, another Trump appointee, the ruling underscores the belief that the nonprofits' grievances should be adjudicated in federal claims court. Given that the groups alleged that their access to funds awarded in the previous year had been illegally denied, resulting in operational paralysis and jeopardizing their sustainability. Seeking reinstatement of their funds, the nonprofits maintained that the freeze had severely impacted their ability to carry out essential work in combating climate change. The court's decision will not take effect immediately, providing the parties involved with the opportunity to appeal. Climate United CEO Beth Bafford expressed determination in a statement, vowing that this ruling does not spell the end of their pursuit for justice. While acknowledging disappointment with the panel's decision, Bafford stood firm on the legitimacy of their case, asserting that the EPA had acted unlawfully in freezing and terminating funds that had been legally obligated and distributed. Judge Cornelia Pillard, appointed by former President Barack Obama, dissented from the majority opinion, arguing that the nonprofits had presented evidence indicating the EPA's disagreement with the program's objectives and its subsequent attempts to dismantle it. Pillard criticized the EPA for leveling unsubstantiated allegations against the groups, stating that the agency had inflicted damage on the Green Bank program without offering any credible evidence or coherent rationale to justify its actions. This part of the narrative often gets overlooked, leaving room for further debate and discussion among stakeholders and the public alike.